where they really feel like they can't put it off anymore. So I've been even busier than usual. Bear with me, I just have to, okay. Had to plug my computer in to make sure I don't run low on battery. So when people contact me to talk about estate planning, sometimes they have a bit of a background in different estate planning options, and sometimes they don't. So I am always prepared to start from just a clean slate baseline. If you know nothing about estate planning, then I hope that the information I'm about to share will give you a good overview of the different options that are available, and also the different benefits and advantages to certain options versus others. So whether you know it or not, you already have an estate plan that was written by the legislature of the state of California. And if you also happen to be a homeowner, then if you just leave things to chance, then if you pass away, your state-written estate plan will wind its way through the probate court. That right now, that's a minimum 2-year process to get through the court system. And if there are any difficulties related with the person's estate, it's even longer. So for many people, the idea of being tied up in court, you know, and it's not really you, because if we're talking about your affairs, then you're unfortunately no longer with us. It's really for the loved ones who you leave behind, that being tied up in court, and then also the expenses that go along with that. We have a statutory sliding scale schedule of probate fees that are paid both to the person who's winding up your affairs and to the lawyer who they hire to assist them in court. So for the average probate case, the fees are usually between 4 and 8% of the gross value of assets. And then you can add on top of that another 8% or so for any real estate that needs to be sold as part of winding up a person's affairs. So if you do nothing, then that is the fate that will await your loved ones. If a person is a homeowner and they have a will, then the same thing that I just described is the most likely outcome. And the reason is homeownership is a big trigger for probate risk in California, because the maximum value that a person can have in terms of assets in their own name on the day they pass away and avoid probate is only $166,250. Prior to this year, it was only $150,000, but the legislature is now just starting to raise that threshold value, and it's going up with inflation. I don't remember how often they adjust it. I want to say maybe every 5 years. But the point is, that number is artificially low compared to real estate values, because the rules use the gross value of a person's assets, not the net equity, as in real estate. We all know that real estate values right now are very high, especially in our neck of the woods, but that the majority of people may not own their homes free and clear. They may have a loan against their house, maybe more than one. And so that decreases the actual net proceeds that they would get. Well, the probate system, they don't take encumbrances into the calculations. They just say, look, if we stuck a for sale sign in front of this house, what's the most likely price we would estimate that we would fetch for it from a buyer? And then that's the value that they use. So most of my clients who are homeowners who don't want their loved ones tied up in the court system, and they don't want their loved ones absorbing the rather high costs of winding up their affairs through the court system, there is another alternative, and that makes up most of my practice, and that is to use the vehicle of a living trust as a way to do everything that you do in a will, but to do it in a way that will avoid the probate court system. And so what I do for clients is I draft complete estate plan packages. The primary document in that package is the living trust, but then there are several other documents that all work together to provide a comprehensive set of instructions in case a person passes away, and also in case a person becomes incapacitated. And I'm going to talk a little bit about that because that has been a big subject of people's focus lately because of coronavirus. So with that, a little more about trusts. Everyone can conceptualize how a will works. You know, you talk to an average adult, they understand, okay, if I pass away, I can sign a document that says, I'm going to leave this person in charge of winding up my affairs. I trust them to pay my bills and expenses and not to run off with my money. And then after they've done their work and handled the administrative tasks, I'm going to direct them to give my assets to these people in these proportions. So conceptually, that's how a will works. Everyone can understand that. A trust does the very same thing. In a trust, you say, I'm going to leave this person in charge. If they're unavailable for some reason, I'm going to name someone else maybe as a backup. And then I'm going to leave my assets to these people in these proportions. So a trust does the very same thing that a will does. The main difference between a will and a trust is that a trust is also a way that you can hold the legal title to your assets. And the reason that's important is you can imagine the trust like a basket. You take the assets that you own, you put them into your own trust, and then you're in charge of your affairs because your trust says you're in charge of your trust while you're alive. But after you pass away, the trust doesn't pass away. And so the value of everything you put in the basket does not count towards triggering a probate. And that is how the trust works, to allow someone to provide for the orderly administration and management of their affairs after they're gone without the necessity of going to court. Now, with that said, if during a trust administration there's a good reason for the family to need the assistance of the court, to have something resolved by a probate court judge, with a trust, you still have access to the court. The primary difference is that court is not mandatory. And so as a result, in the overwhelming majority of cases when we administer affairs through a trust, we don't end up having to go to court because the trust provides ways to resolve, what if situations that come up. For example, what if something happens to the primary person who's named to be in charge of a person's affairs? We will have backup people named very frequently. And if all of the backup people are not available for some reason, then trusts frequently will have a mechanism in place so that we have an orderly way to fill the vacancy of the office of trustee to make sure that the work gets done. And we do similar things for beneficiaries. Sometimes a person who is named to receive a portion of someone's assets doesn't survive the person, so what do we do? And the trust will have backup provisions built in the same way that a will would, and the same way that the law by default has certain backup provisions built in. The difference is with the trust, sometimes people don't want to use the default provisions that the legislature has written for everybody. So that can be an important reason to set up a custom document like a trust to get one's affairs in order. So all of that is built into the trust. I walk clients through the different kinds of options that they have as far as how to name people as backup people, also how to sort out, well, if something happens, say, to one of my children, I want their share to go to any surviving children they may have. Because, if the child's already orphaned, I don't want my grandchildren getting the double burden of losing a parent and not getting the benefit of what the parent would have otherwise left to them, had they survived. So that brings up the possibility of young people becoming entitled to receive a portion of a person's assets. And most of my clients don't like the fact that by default, when a person's 18, in the eyes of the law, they're an adult. So the law just says, well, they can handle it. Here's all this money. Most of my clients lose sleep over the idea of a young person coming into a lot of money. So trusts very frequently will have a provision built in that says, we're going to establish a minimum age below which a person will not receive an outright distribution, even if they happen to be an adult. And so the trust contains language that sets out how the trustee is to manage those shares, sets out what that minimum age is. And with my clients, we start with an age of 25, just because in my experience, most people nod their head and say, yeah, by 25, the person should be mature and responsible enough to handle receiving the money. And so the trust already deals with those kinds of eventualities and those common scenarios that can come up after someone has passed away. So in addition to the trust, we have to make sure that assets are placed into the trust, and the way we accomplish that is the trust itself contains very broad language that says, I intend everything I own to be a part of my trust. And for most assets, the trend now with courts is they will say, hey, that's good enough. We know the person's intention was to avoid probate. So if there's a question of whether an asset is in the trust or not, in most cases, the language alone in the trust will allow a judge to say, you know, we don't have to probate this particular asset. We're going to allow it to be treated as part of the trust. I don't like loose ends, so with my clients, we also include a general declaration that everything that a client owns as of the date that they sign the document is really intended to be in their trust for the purpose of avoiding probate. That document, together with the broad language in the trust, tends to really convince judges that what we said in the documents is what we meant. For real estate, because of tradition, land rules are very, very specific. And because of my background in real estate, I could bore you all to tears with the rules and the exceptions to the rules and exceptions to exceptions, but I won't do that. I'm not. Monday's hard enough as it is. Just suffice it to say that best practices for estate planning lawyers dictate that for real estate, we're going to use a deed so that a person takes the property that they already own and they deed it to themselves as the trustee of their trust. And then what I do is I record that deed in the county land records, and that is the way that we give evidence that the land that we're talking about really is a part of the trust estate. So that's how we ensure that everything that a client owns ends up being considered a part of their estate within their trust. And then even though the trust does everything that a will does, clients with a estate plan still get wills. And the reason is sometimes unusual things happen related to a person's trust. The two most common things that will come up, sometimes a person will acquire an asset well after they've established their trust. And maybe they didn't have a declaration that says, hey, everything I own is really part of my trust. So sometimes there can be a question of whether or not an asset was intended to be a part of a trust. And so the most common thing that a will does for people who have a trust in that kind of situation is it removes all the doubt, because the will says anything that I didn't put in my trust during my lifetime, or anything where maybe it's not clear and it's arguably outside my trust, my will puts it into my trust. So what that does is it removes the doubt so that everything is administered consistently according to the language in the trust. The other thing that might come up, and it's very rare, in my 15 years of practice of law, I've seen it happen precisely one time. Sometimes a trust can become invalid after a person has signed it. The most common way that that occurs is people write on their trust sometimes to try and make their own changes. And this is not a DIY kind of affair, but I see it every few months. I'll see a trust that someone will bring in, and they've written all over it. And when a person does that, in a worst case scenario, it can introduce an ambiguity that a judge cannot reconcile. If we can't read that document and say, we're really confident that what the person meant to do was X, then we have to go to a judge. And if the judge agrees and says, you know what, I don't know what they meant to do either, the result is the judge throws out the entire trust, and then we end up in probate. So in the very unlikely event that that happens, the will has a provision that says, hey, if for some reason the trust is invalid, then the will is going to undo whatever occurred to make the trust invalid. And the way that the will accomplishes that is to create a brand new trust on the terms that were in place right before the trust became invalid. So you can think of the will as having a reset button built into it. The will allows us to avoid the eventuality that we're not going to do what it says in the trust. So with all of those things in place, it is very, very unlikely that we would end up in a position where we couldn't do what the trust says, as long as the trust is valid. So those are the primary documents in a person's estate plan that provide for What do we do in case someone passes away? Those documents together provide a comprehensive set of instructions. We know who is in charge. We know who's named as a backup. We know how assets are to be distributed primarily, and we have a backup plan for distribution in case something happens to any of the primary named people. So that's most of a estate plan that I provide for my clients. The other portion of estate planning that has really kind of taken the spotlight in the past several months has to do with incapacity. A few months ago, I met with a client and we talked about establishing an estate plan for them. But while I was talking to that person, I realized that they really were unable to understand the nature of the conversation because, as it turned out, they had received a dementia diagnosis previous to meeting with me, and their dementia was progressing at a much faster rate than anybody realized. So when I have situations like that, and in estate planning it comes up sometimes, I go out of my way to make sure that I'm not doing more harm than good by establishing an estate plan that won't stand up in court later, because for obvious reasons, when a person is unable to make those kinds of decisions, anything that they sign is not legally enforceable down the line. So as a result, what happened was I had to advise the family, well, do you happen to have a power of attorney for this person in case they're incapacitated? Do you happen to have an advanced healthcare directive that they signed, like right when they got the diagnosis? And unfortunately, in this case, the answer was no. And so the only thing that I could do was direct them to another lawyer who does conservatorship cases in court, because when a person doesn't have a legally binding document in place already that says, if I'm incapacitated, I trust this person to be in charge of my financial affairs, and I trust this person to talk to my doctor for me, then the result is we have to go to court to have a conservator issued over their person, which gives the person authority to talk to their doctor, and over their estate, which gives the person the power to be in charge of their financial affairs. So a durable power of attorney and an advanced healthcare directive, by having those two documents together, my clients should never need to have someone go to court to have them conserved, because those documents serve as a substitute for an order from a judge appointing someone to do those things. And right now, as I'm sure you can imagine, people can take ill very quickly. I just had to cancel my first appointment for a client where a member of the household was diagnosed with coronavirus. So now the whole household is being quarantined. So these things are coming up, and they're becoming more front and center just as this pandemic continues to play itself out. So this has become an area in estate planning where historically I didn't spend a whole lot of time focusing on it, but right now, because of what's going on, this is something that's very important for people to understand. So the financial durable power of attorney is a document where a client will say, if I'm unable to manage my affairs, then this is the person who I would trust to manage my affairs for me. And what I usually recommend for clients is that for all of the financial documents, the things other than the advanced healthcare directive, that we name the same people in the same order for practical reasons, mainly having to do with financial institutions. When we have different people named, and it's more important for a married couple than it is for a client who isn't married or who doesn't have a domestic partner. If we have different people named in the documents and then we have a joint bank account, the bank gets very confused very quickly as far as who they're allowed to talk to and so forth. So for that reason, for financial documents, I tend to recommend that we take a single file line approach to who we name and in what order. So the financial power of attorney allows us to make sure that we know who's allowed to go to the bank, who's allowed to talk to an insurance company, for insurance coverage issues and things of that nature. The advanced healthcare directive does the same thing, just in a more limited capacity, in that the healthcare directive is a special kind of power of attorney just for the purpose of allowing a person to talk to your doctor for you. So if you are unable to make your own informed medical decisions, then we know who your doctor is allowed to speak with. And the healthcare directive also includes specific provisions for the scope of authority and the kinds of decisions that you would make if you were able to speak for yourself, for things like life support, end-of-life care, organ donation, making funeral arrangements, authorizing an autopsy if there's a chance of medical malpractice or something like that. So those two documents are just as important. And in fact, because it's more likely that a person may become incapacitated for a time during their life versus just passing away unexpectedly, we know right now that those documents are just as important as the trust and the will, because it is just as likely that you might need someone to manage your affairs on a temporary basis. So that's what those documents are for. And together, by having all of those documents, the nice thing is that the end result is that we now have a comprehensive and orderly set of instructions where we're going to know if this person gets sick, we know who's allowed to talk to their doctor. We know who is allowed to go to their bank and manage their financial affairs for them. And then if they pass away, we know who's allowed to wind up their affairs. And we know the people to whom they are to give assets after they pay debts and expenses. And we also know what to do in case of an unusual situation coming up if one of the named people in the documents isn't around to serve in those capacities. So really, in a nutshell, that is how the estate plan process works. That's how the documents are intended to work. I can speak really briefly on a few common scenarios that come up after a person has an estate plan, some common questions that I address. I actually provide my clients with a set of comprehensive instructions after the estate plan is done. The good news is that the hard part of estate planning for the average client is just getting to see me to begin with. So once they've taken care of that, they've really handled the hard part. After an estate plan is drafted and signed, there are only a couple things that most clients need to attend to, and those have to do with homeowners insurance. There's something called a trust endorsement that I advise clients to contact their homeowners agent to say, hey, I have a trust now, and because homeowners insurance is something known as a named insured policy, the house is already in my name, but now I want you to just add me as trustee of my trust so that if we have to file a claim, we don't get any headaches or complications in the claims process. The more pressing matter that clients need to attend to has to do with financial accounts. My client's bank or their retirement company or investment company will not talk to me. They don't know if I'm a lawyer, and they don't know if I'm really the client's lawyer. And so for obvious reasons having to do with identity theft, they just have a policy. They don't talk to non-account holders without jumping through a lot of hoops. But they will talk to my clients because my clients are account holders. So to make sure that money that a person has deposited with their bank or invested in retirement accounts or investment accounts do not unintentionally trigger a probate in themselves, what I advise clients to do is they can update their pay-on-death provisions very easily directly with their financial institutions. Just about every financial institution has its own form that says, hey, I'm an account holder, if I pass away, give my money to this person, or in this case, to my trust. You can actually name your trust as the pay-on-death recipient. For married clients, I often advise for a retirement account, because they're usually in one name only, name your spouse first and then name your trust as a backup. Now, it used to be, prior to this year, there were some negative tax consequences to naming a trust versus a person. So historically, financial planners and retirement advisors would say, well, actually, no, name people first and then name the trust as the last resort. Unfortunately, last year, the Congress changed the tax rules. So now the primary benefit for a non-spouse recipient of a retirement account versus your trust, it has largely gone away. And as a result of that, and also because for a lot of my clients, there's a chance that young people like grandchildren or even children, I have clients who have minor children, what happens is if they're named by name on those accounts, then when they turn 18, the money just goes to them. And for a lot of my clients, for the reasons I explained when I was talking about the minimum distribution age, that becomes a risk factor for them. So they would rather pay the tax, have the money go into their trust, and then grow the money to make up for the tax that they pay. So for a lot of my clients, naming the trust as the pay on death recipient for their money means that the money goes into the trust, and then it's available to the person who they've left in charge to pay expenses and things like that, and then ultimately to distribute what's left over to the beneficiaries, but also to allow the trustee, if they need to manage those assets for the benefit of young beneficiaries. So those are common scenarios that come up. And then there's another common scenario. I have a trust and I want to refinance my house, and my lender says I have to take my house out of my trust to do it. I provide instructions to let clients know, just make sure you tell your title company, hey, give me another deed to put the house back into my trust. Sometimes people will ask, well, if I buy a new house, what do I do? And the answer is really simple. You tell your title company and your real estate agent, I have a trust and I want to hold title in my trust. And if your lender who's giving you the loan to buy the house doesn't want you to hold it in trust, you do the same thing as you would for a refinance. And then if you're selling a house that's in a trust, you just sign off as the trustee of your trust. So those are common things that people will ask about. And what I do is with my clients, I just include in the instructions, hey, if you have one of these common things come up, here's how you handle it. So with that, I just try and break things down for clients to make them as straightforward and easy to understand as I hope the information I've shared with you this morning has been. With that, that's really my quick standard overview of estate planning for clients. So I'm happy to open it up to questions, and I want to thank you for taking the time to meet with me today.
Right. Before we start with questions, I want to mention that Jason has to leave a little earlier than we planned. So we're starting with questions now, but after he leaves, we'll take as many questions as possible. And Jason has agreed to meet with me to get the answers so that we'll help you with your questions. So let's go. And would you raise your hand if you have a question? Sarah Becerra?
Unmute.
Yes. Okay. Hi. Thank you so much. You're very clear. Really appreciate this. So you were talking about the need for a will if your assets change, something changes. Why not just make that in the trust?
Well,
yeah.
Yeah, so the will is actually a safety net that is there in case something unusual happens with the trust. When a client acquires new assets, you don't need to change the trust and you don't need to change the will either. For personal property, it's already going to be treated as part of your trust just by law.